My name is Katie Gabhart. I'm the Executive Director of the Executive Branch Ethics Commission. And this is Jenny May. She's the Lobbyist Coordinator for the Ethics Commission. Jenny's been with us for 25 years, and she is the expert on lobbying and registering to be a lobbyist. So I do my best to try to understand it. I've only been with the commission for 8 years. So I do my best to answer the questions, but a lot of times I'll go to Jenny, and she helps me out. As many of you are aware, Senate Bill 6 was passed at the last legislative session that drastically changed the definition of lobbyist and who has to register as a lobbyist. We didn't draft the language in Senate Bill 6, so we're still trying to figure out what some of it means too. I really hope that at the next session we have some cleanup language, and I've already talked to the bill sponsor about us doing just that. So I'm hoping that as we move forward in the future we get more clarity on exactly how this is going to apply. We do have an executive agency lobbying handbook. We don't want to hand this out unless you're serious. We only have 100 copies of this handbook. It is kind of expensive for us to print. So if you're not interested in registering as a lobbyist, please don't take one of these. If after this session you believe you really need this information, please come on up to the front and we'll hand them out to you. We will also have this document available on our website as a PDF. Okay. So let's get started. The Executive Branch Ethics Commission, our main job, well, we have two main jobs. We enforce the Executive Branch Code of Ethics on all public servants who work for executive branch agencies and state government. That's one half of our job. We're not going to talk about that today at all. If you're interested in learning more about the ethics code that applies to public servants, we have other trainings we do, and you can just look on the home screen of our website, and we post when those trainings are. But today we're going to talk about the other half of our job, which is to enforce the provisions of registering for lobbyists, and there are certain rules that lobbyists who are going to be lobbying the executive branch have to follow. And those provisions are contained in KRS 11A 201 through 246. Senate Bill 6 affected several of the provisions in these statutes. Again, today's not a CLE, so this is, I think, the only slide in which we have citations to statutes. We tried to not go down that path. Now, we do have a regulation, 9KAR 1040, which specifically applies to the registration process for lobbyists. And there are penalty provisions contained in KRS 118990. If you want to know the specific statutes and how they apply, it'll be in the handbook. We also had another training we did back in June that we really went into the weeds of the statutes, and we have recorded that. We have a PowerPoint of that session that is on our website, and we will soon have a video of that training on our website. So today is more of an introduction, and that other session is really getting into the weeds, into the particulars of the statutes. Now, today we're only talking about if you're lobbying officials of the executive branch. If you are at all interested in lobbying the legislative branch, you need to contact the Legislative Ethics Commission. If you are interested in lobbying local government, county or city officials, you need to check out the local ethics code for each county or city, which is posted on the Department for Local Government's website. So again, we're only talking today about if you're going to be lobbying executive branch officials. Okay. So what is professional lobbying? Anyone who is paid by a client or employer to influence the decisions of executive branch elected officials or state agency officials. If you are not paid, then the rest of the session will not apply to you. So if you're a volunteer and you don't get paid either a salary or get paid an hourly fee or have some sort of payment compensation arrangement, then you do not have to register with the Ethics Commission, regardless of what applies with the rest of today's talk. What is executive agency lobbying? Well, that is anyone, again, who is paid to attempt to promote, oppose, or influence the outcome of an executive agency decision by making contacts to officials, but only if those contacts are made to influence a decision involving a state agency, either that would result in the expenditure of state funds over $5,000, such as through a contract, or would financially impact your client or employer. So we're going to get into each aspect of this and what it means. So, to repeat, there are two thresholds. If these two thresholds don't apply to you, nothing else in this session will apply to you. So first and foremost, you have to be paid, not a volunteer. And the state decisions, again, executive branch agency decisions you are trying to influence will benefit your employer or client financially. If you don't meet those two thresholds, you don't have to register with the Executive Branch Ethics Commission. Okay, so Senate Bill 6, what it did was expanded some definitions. Executive agency decision, executive agency lobbyist activity, and substantial issue. If you have any experience being an executive agency lobbyist, that substantial issue used to be called, substantial basis. So that term substantial basis has now changed to substantial issue. Senate Bill 6 also changed the registration statement, so all the forms you have to fill out as a lobbyist have been revised. And Jenny, the second half of this training, Jenny is going to go through all of those forms and statements. So, but the main change that happened through Senate Bill 6 is the registration statements now require the executive agency lobbyist and the employer to list the compensation they receive. They also must certify that they have not received a contingency fee, and then the Senate Bill 6 also expanded what the definition of contingency fee is. Okay, so the definition, what is an executive agency decision? This definition has been greatly expanded, and I think that's why most of you are in this room today. So what is an executive agency decision? It's a decision made by an executive branch state agency, either through a constitutional officer or a cabinet or any of the boards and commissions, departments, or divisions attached to a cabinet. And the decision is concerning the spending of state funds by awarding a contract, grant, lease, or other financial arrangement. This part has existed in the ethics code before, so this isn't new. What is new now is an executive agency decision can be a decision to decide the parameters of contracts or agreements with the state, decisions about requesting future or existing budget provisions, decisions concerning the issuing of administrative regulations or rules, or even doing an amendment to existing administrative regulations, issuing an executive order, influencing legislation. So a decision by an executive branch agency to influence legislation that would come before the legislature, or any other public policy decisions. What does that mean? That's a good question. We hope we get some more clarity on that at the next legislative session. So what if the executive agency decision has already been made? I get a lot of questions about, well, I just want to attend a meeting, or I just want to give a comment. This Senate Bill 6 and the new changes do not apply if the decision has already been made. And the only contacts you are going to have are part of the ordinary process. You do not have to register with the Ethics Commission. So some examples of that, you just want to submit a bid on an RFP, a request for proposal. The RFP's already been issued. The decision's already made, or the agency has already made the decision to issue the RFP. So the only contacts you're making are through submitting a bid. you don't have to register with us. But if you are going to be making contacts with the agency to try to influence them to submit an RFP or try to influence what goes into the RFP, then you do have to register with us. Of course, keep in mind there are provisions in the Model Procurement Code about what kind of contacts you can have with executive agency officials as well. That's outside of our rules. Another example is all you want to do is submit a comment during an open comment period concerning an administrative regulation. You don't have to register with us just to submit a comment during the regular open period. Attending an open meeting, any open meeting of a board or a commission, a committee, a council, a task force, any type of open meeting, you don't have to register with us to attend. Say you want to make comments during that open meeting. Again, you don't have to register with the Ethics Commission to do so. Again, attending committee meetings, speaking for or against legislation in an open meeting, you don't have to register with the Ethics Commission. All of this is contemplating that you're going to be making contacts outside of these processes. If you're going to make contacts outside of these processes or even before them, then you would need to register with the Ethics Commission. So who should register as an executive agency lobbyist? Any individual who is conducting lobbying, who's being paid to do so, and your client or employer will be financially impacted by those executive agency decisions would need to register with us. If you do so, we call you an executive agency lobbyist, or EAL. So throughout the rest of today's training, we use the term EAL. So who's to register? An EAL is any person who is engaged to influence executive agency decisions or to conduct executive agency lobbying activity by making contacts to agency officials as one of his or her main purposes regarding a substantial issue. So what does that mean? So let's break it down by each term. So everything I just said in the last slide, I'm going to break down by each term. So who should register as an EAL? Well, what is a person? Well, a person, we have a definition in the Ethics Code that's very expansive of what a person is. It can be an individual. It can be a business, a firm, a partnership. It could be a joint venture or a syndicate, a statutory trust, donative trust, or an estate. It could be a company or corporation or LLC. It could be an association or a club or committee or any organization, whether or not for profit. That's key. It could be a group of persons acting in concert. All of those things could be considered a person. Next, okay, so you have a person who is engaged. Well, that doesn't mean engaged to be married. It means something specific. It means you have some sort of arrangement, either a contractual arrangement, a verbal, a written arrangement with your employer or with your client, in which you are paid to influence executive branch state agency decisions. So you have an arrangement. Being paid means you receive compensation, either through your salary, working for your employer, or payment by your client. This includes money, or it could be things of value. It could be some sort of economic benefit, like stocks or bonds or that sort of thing. However, keep in mind, your payment, your compensation cannot be a contingency fee arrangement. They're strictly prohibited, and it's actually a Class D felony. So I'm going to really describe what that is towards the end. So who should register? Again, we've got a person who is engaged to influence executive branch state agency decisions or to engage in activity that's executive agency lobbying activity. What does that mean? You make contacts to promote or oppose the passage or modification or defeat of some sort of executive agency decision. That could be getting the governor to approve something, getting him to veto something, It could be influencing the outcome of a cabinet through direct communication with the cabinet secretary or his or her employees. You could be making contacts directly to an elected official or to the elected official staff, directly to anyone in the upper level of a cabinet or their staff. Now, if you're only making contacts to lower level employees that aren't involved in the decision making, then you don't have to register with the commission. This is those making decisions or influencing the decision makers. So again, who should register? It's a person who is engaged to influence an executive agency decision by making contacts to agency officials as one of his or her main purposes regarding a substantial issue. So what's that mean? You make these contacts on behalf of your employer or client to influence a decision that involves state funds to be issued totaling more than $5,000 in a calendar year. So that could be through a series of disbursements. It could be through a one-time amount. It could be through a contract, or it could be through an MOA or some type of agreement. However those disbursements are had, if you're trying to influence a decision for the disbursement of $3,000, you don't have to register. But if you are trying to get the disbursement of $5,000 in state funds, then you do have to register. Or you're trying to influence a decision that would be a budget provision, an agency regulation or rule, a legislative matter, or other public policy decision that would financially impact your employer or your client. So what does financially impact mean? Well, Senate Bill 6 does not define this. This is, again, one of those terms we would like to see defined at the next session. But just looking at the ordinary dictionary definitions of financial and impact, what we believe it means is it would be a decision of a state agency that would have a positive or negative effect on the financial position of your employer or client. It could be you want to influence, say, the Department of Fish and Wildlife to change their commercial fishermen regulations that would positively affect your client who is a commercial fisherman. It could be that kind of type of contact you want to have. Or it could be an agency has regulations that financially negatively impact your client, and you want to influence that agency to change the regs so it would better your client's financial position. Who should register as an EAL? Okay, I think this is the last slide on this. An executive agency lobbyist also includes, and this again is new language from Senate Bill 6, representatives of associations, coalitions, or public interest entities formed to promote or influence executive agency decisions. So if you have a nonprofit organization and part of your bylaws are to lobby executive agency officials, then you would need to register if you're being paid to do so. This also covers placement agents. Placement agents are individuals who are hired to influence the Kentucky retirement systems or the Kentucky teachers' retirement systems. And it also covers unregulated placement agents, which are individuals who are barred by the federal securities laws from receiving compensation. So that is the one entity. Unregulated placement agents may not be paid, but they still have to register with us if they're going to be engaging in this conduct. What is an executive agency? You'd think that'd be easy for us to figure out, but it's not. Every time the legislature meets, they create some sort of new task force or quasi-governmental corporation, and we have to figure out whether that's an executive branch agency. For you, keep in mind, this can be an elected constitutional officer, so the governor, lieutenant governor, secretary of state, AG. It could be, I don't want to leave anybody out, commissioner of agriculture and auditor. It's all the cabinets listed in KRS 12250. I lied, there's another statute. Sorry. So any of the cabinets that are directly under the governor, any agency, department, board, or commission controlled or directed by an elected executive official. So there's a couple of independent entities out there. Specifically, the Executive Branch Ethics Commission is independent. If you were trying to lobby the Ethics Commission, we don't have any money to give you, so don't worry about lobbying us. But there may be some exceptions to this for independent entities. Do you know of any that aren't on your list? Okay. Executive agency does not include, of course, the judicial branch and the legislative branch. It doesn't include local governments. But here's one surprise. It does not include higher education or local public school systems. I don't know whether or not those entities have their own ethics codes that cover lobbying. I think most of the lobbying that is done is to the Department of Education, so you would have to register if you're lobbying the department. Okay, who is an EAL? An employer of an EAL. An employer means any person, and again, person is an expansive definition, who employs or engages an executive agency lobbyist. For instance, this could be a firm that the employee the EAL works for on a permanent basis, or it can be the client of the lobbyist. Now, what is a real party in interest? A real party in interest is specifically mentioned throughout the lobbyist portion of the ethics code, and a real party in interest is someone who also may need to register. A real party in interest is the person or organization on whose benefit the EAL is acting, if that person is not already listed as the employer. For example, this could be, you have ABC Corporation that engages or has a contract or a relationship, a client relationship with XYZ Consulting Company, which in turn hires John Smith to be the lobbyist, to influence decisions or to conduct some sort of lobbyist activity. And that John Smith is going to be lobbying on behalf of ABC Corporation, but his employer is XYZ. So John's employer, John is the EAL, so whenever he fills out forms, he's filling out the EAL forms. XYZ Consulting is the employer, and ABC Corporation is the real party in interest. Now, some individuals, instead of listing their clients as the real party in interest, some file as the employer. It really makes no difference for us as long as they're filing the forms. Correct? Okay. So who is exempt from filing? So there's a big group of people that don't have to file. Unpaid lobbyists. Again, if you're not being paid, if you're volunteer, even if you're engaging in this conduct, you don't have to register. Persons exercising their constitutional right to assemble with others for their common good and petition the state through making contacts to executive agency officials to redress their grievances. It's a constitutional right. Persons whose contacts with state officials are for the sole purpose of submitting open records requests. You don't have to register with us. Can you imagine everyone who submits an open records request? A person whose lobbying is done only during appearances before executive agencies during public meetings, and a person submitting public comments to an executive agency during an open comment period. Did I mention this training is a little bit repetitive? We want to make sure you understand. Who is exempt from filing? Also, any person whose contacts are limited to those employees of whose official duties do not include policy formation, administrative or supervisory authority, or the expenditure authorization. So again, those lower level employees who can't make the decisions. A person who is elected or appointed officer or employee of a federal or state or local government. So if you work for the state, if you work for the executive branch or the legislative branch, and part of your job is to lobby the other branch, you don't have to register with the Ethics Commission. You know, part of my job representing the commission is to lobby the legislature. I don't have to register with the Legislative Ethics Commission. Who is exempt from filing? News media. Pretty much anything the news media does. They don't have to register with us. A person or entity who's gathering information for the news media does not have to register with us. Publications of associations or charitable or fraternal nonprofit corporations, just your publications alone, if you're not making direct contacts with executive branch agencies, you're just creating a publication that you might provide to an executive agency official, does not require you to register with the Ethics Commission. And then professional services performed in preparing decisions for executive branch agency officials. So say you're an attorney that has a contract with an executive branch agency and you're just fulfilling that contract, you don't have to register with the Ethics Commission. Who is exempt? A person whose job does not include lobbying as their main purpose. So, for example, you have an engineer who works for a public utility who sometimes is in contact with the state highway officials about moving utility lines for right-of-way, but it's not his main job to engage in lobbying for his agency. A person acting to promote or oppose or otherwise influence the outcome of a decision of a cabinet for economic development relating to programs or economic incentive packages of that cabinet. So they have a specific buyout from dealing with us. Now, how to register. This is the point in the session where I'm going to hand it over to Jenny, and then she's going to give it back to me, and I'm going to talk about contingency fees and penalties for failing to register. Thank you.
Okay, thank you. To register with us as an executive agency lobbyist, to register your employer, you'll complete what's called the initial registration statement. And that's online at our website, and it's also included in the handbook. Each EAL must file, are you going to click through? Oh, I'm sorry. That's okay. Each lobbyist must file an initial registration statement that registers the lobbyist, the employer, and the real party and interest simultaneously all at the same time. There is no fee that is paid when you file the initial registration statement. The fee is collected when the employer and the real party file their updated registration statement in July. If you're an executive agency lobbyist that's engaged by more than one employer or client, you have to fill out a separate initial registration statement for each employer or each client that you're representing. And employers must ensure that each individual that is conducting executive agency lobbying activity is registered. Each lobbyist, employer, and if applicable, real party and interest, you're required to file your initial registration statement within 10 days of your engagement. If you're an employee, an in-house employee of a company, you may have worked for that company for 20 years, but you may have been assigned the task for a particular issue or a particular contract that you're wanting to influence, then your engagement date would be the date that you began that activity or the date that you were assigned the task. For most contract lobbyists, most of the time it's going to be the date that you entered into an agreement to represent that client. The initial registration statement, well, we don't have the handbooks, but that's okay. It's going to be hard for me to see that far away. That's fine. The first section, you're giving information about the lobbyist. It's just basic boilerplate contact information. The same is true for the employer. You want to make sure that your employer contact that you list on that form is going to be the person that's going to be responsible for completing the employer update, as well as making sure that the registration fee is paid in July. And then you have the real party and interest information. If that's applicable, it's kind of the same as the employer. You'll fill that out. And then on the subsequent pages, which I don't think...
No, that's just an example.
It's just an example. I'll just hold it up. There's 3 pages that list all of the executive branch cabinets and agencies and constitutional officers, and you'll want to check off the ones that you anticipate lobbying. You'll also be asked to give a brief description of why you're registering, what do you anticipate trying to influence, and then you also list the compensation that's going to be paid to you to represent that client. And the statute was not real clear on how to list the compensation, so we just have this boilerplate language in the instructions that I'll read, which simply states, the statute does not establish a specific method for the reporting of compensation, whether that be monthly, annually, prorated amount based on percentage of time actually conducting lobbying activity. For compliance purposes, provide a good faith answer to the best of your knowledge. And that's all we can ask you to do at this point.
If I can interject.
Yeah.
If you are currently a registered lobbyist, you probably just went through the filing period. You used the 2016 forms. So the next time you have to file those forms, or if you're going to be a newly filed lobbyist during the next year, at the filing period that starts next July, you will be using the 2019 forms. So this pamphlet, this booklet, has only the 2019 forms. So the 16 forms are done. Everything we use from here on out are the 2019 forms. We hope, keep your fingers crossed, we will have an online filing system live and active by next filing period. We worked on it, wasn't ready. Then we had the legislation passed. We're like, we're not doing two different filing systems, so we waited. We didn't launch it this time. So we hope to have that launched by next year, long before the filing period starts.
Okay. Once your initial registration statement is received in our office, it's processed. Both the lobbyist gets a confirmation back from our office stating that you are registered. You get a registration card with your EAL number, and that's supposed to be used on all of your updates and any correspondence that you have with our agency. The employer also gets a confirmation that they are now registered as an employer, and both of those communications contain information about what your requirements are going forward now that you're registered. How long is the registration valid? After the statement's processed, the EAL, that's what I just said. Until an EAL files a termination notice with the commission, the lobbyist and your employer or your real party are considered active, and you're still required to file updates each July and pay the registration fee. And the problem that I run into a lot with this is a lot of times lobbyists will remain active because they anticipate something coming up in the future, and that's fine, you can do that. But if you're active, that employer is active, and they're the ones that pay the fee. So if you're listed as active for that employer or that real party, they will have to pay the fee come July. So I get a lot of people saying, well, we haven't paid that firm or we haven't paid that lobbyist in 2 years, but if they're on the books as active, that employer and real party has to pay. So, okay, who must file an updated registration statement? Each July, what I call the reporting phase, which is July 1st through June the 31st, every lobbyist, employer, and real party in interest has to file what's called an updated registration statement with our commission. It's doing exactly what the form says. You're updating all the original information you gave us on your initial statement, but you're also going to be reporting your activity you had for the prior year. Our reporting period operates on a state fiscal year, which is July 1st through June 30th. So for example, the updates and the registration fees that I collected this past July are for the reporting period that began July 1st of 18 through June the 30th of 19. So if you think of income taxes, you're reporting and paying for the year that just concluded. There are 4 forms, updated registration statements. There's the individual lobbyist form, the individual employer form, the individual real party and interest form, and then we have what's called a combined form. And that form is used. There's 4 situations that have to be in place in order to use a combined form. You have to be the one and only lobbyist for that employer. You also listed yourself as the employer contact. You had no expenditures or no financial transactions to report. And that form is password protected, and the reason it is because we have a lot of people that would want to do the short form that aren't qualified to do so. So if you are qualified, I'll determine if you're qualified to do that form, and when the reminder notices go out in the end of June, you'll be given instructions on how to access that form. As I said earlier, a reporting year runs from July 1st through June the 30th. The statements are due between July 1st and July 31st for the previous reporting period, and statements filed before July 1st will be rejected. Obviously, it's assumed that you could be lobbying up until June the 30th, so you need to wait and file your reports until July 1st. The registration fee is paid by each employer or each real party in interest, and that's regardless of how many lobbyists you have. If you have one lobbyist registered, you pay $500. If you have 15, you pay $500. It is not paid per lobbyist. Failure to file, both the initial registration statement and updated registration statements must be complete when filed. If you fail to file the form, or, well, let's start with the initial registration statement. If there's any omissions or deficiency, you'll be given an opportunity to correct those. I usually reach out to you if I find something that's not on there or I have a question, and you'll have an opportunity to make that correction. The same is true if you do not turn in your updated registration statements. I usually reach out to everyone and give you more than ample opportunity to get those in. Once we have done that, you'll be, if I don't get a response back from you in what I consider to be a reasonable amount of time, then you'll be notified via certified letter. You'll have 15 days from the date that you receive that letter to correct the deficiency, whether it's you failed to file your update or you failed to pay your fee. If not, then an investigation is initiated, and by that time the maximum fine will be in place, which would be $1,000 for failure to file. But I do try to give everybody as much opportunity as I can, probably do more hand-holding than I should, but that's just what I've always done. So
I want to say at this point, this lady is a saint. Yeah. There's over 1,400 lobbyists. I suspect that number's going to go up, so
probably. Yeah.
I do want to say, so we have these deficiencies. At any time you need to amend your forms, we will accept an amendment. Once you find out maybe an omission, something was omitted from the form, we give plenty of opportunity for you to come in and change your form. Now, if we find out from another source that you didn't provide sufficient information, then that's a different story. I'm going to talk about that in a few minutes.
Okay.
Sorry.
There you go. There's 4 basic types of information that you'll be reporting on your updates. The first is a confirmation that you're going to continue your registration into the next reporting period.
Ma'am, do you want one of these?
The next, you'll be, as I said before, updating any original information that you put on your initial registration statement. A lot of times there's mergers, companies buy out other companies, so you may have a change in employer name, you may have a change in the employer contact. So you'll update that information. You'll confirm whether or not you're continuing your registration. You'll list your specific executive agency decisions that you tried to influence during the last year. And I always tell people a 1-year period is a lot to keep up with. So if you know, whether it's a work diary or something that you have where you can go back and kind of recapture the information in terms of who you made contacts with, what the nature was, what you were trying to influence. Many people it kind of runs the gamut. I get sometimes people that attach a 2-page laundry list of everyone that they talk to. Some people are very brief in that section, but do try to be as specific as possible. The next is a statement of expenditures. If you made any expenditures on behalf of an executive branch official, whether that be meals, entertainment, travel, sporting events, that type of thing, you're to list that under your expenditures. And there's a table where you list the executive branch official, the date, the nature of the expenditure, and the amount. Details of any financial transactions, those I think we define later on in this PowerPoint, and then the compensation paid to the lobbyist by the employer. What is a financial transaction? That is if you have some type of business relationship between yourself, an immediate member of your family, your employer or client, and an executive agency employee. And that usually involves owning a business together, owning rental property together, or something like that. It's very rare. If you do have financial transactions, at least 10 days before the date on which the statement's filed, the filer shall deliver a copy of the statement to the official or employee with whom or for whose benefit the financial transaction was made. The official or employee may dispute the information contained in the statement.
Has that happened?
I've never had that happen since I've been here. No. Disputes between executive branch officials, employees or parties in interest, employers or EILs may be investigated by the Commission upon the filing of a complaint by any party. A complaint must be filed at least 3 days prior to the time a statement is required to be filed with the Commission. Again, I've never had that happen. Doesn't mean it won't, but I haven't. When an EIL has only one employer and that employer has only one EIL, and they are both the employer contact as well as the individual lobbyist, that can file what's called the combined report. And it can only be used if either the EIL or the employer has no expenses or financial transactions to report. And the employer is still required to pay the $500 registration fee even with a combined report. An EIL is required to notify the Commission within 30 days after the termination of an engagement by filing a termination notification form. The form should be completed, signed, and attached to your final updated registration statement. And let me just interject, if you're terminating, a lot of times I get terminations that coincide with legislative ethics terminations, and that's fine. But do keep in mind, you will always owe me a final update because we have a 1-year reporting period, and the same is true for the employer. Even if it happens in the middle, December, January, November, whatever, you're always going to owe me a final report because we operate on a 1-year reporting period. And if it lasts even 1 day into the new reporting period, then they must file updated registration statements for that period. And that's your termination notification statement. And there is it does require the compensation to be reported on that form. So you would, if in the example I gave previously, if you're terminating in the middle of the year, you'll report your compensation received from the beginning of the reporting period to your termination date.
And this is going to actually seem repetitive because on the update form that you will be filing at the same time as your termination, you have to list your compensation as well.
Right.
So if you put the same thing on each form, that's fine.
That's fine. When an employer or real party in interest has terminated the engagement of all of their lobbyists, they have consequently terminated their registration with the Commission. We don't have a formal process for an employer to terminate. It's just a matter of if all of your lobbyists have terminated, then you have, in effect, terminated. A final updated registration statement and registration fee must be submitted to the Commission. So just keep that in mind if you're terminating a client or you're leaving an employer as an in-house lobbyist and you or all of the lobbyists are terminating, which means the employer terminates, they'll still have to file a final updated registration statement and pay the registration fee. Your record-keeping requirements are that if you had receipts or anything involving financial transactions or expenditures, you're to retain those for, I'm going to make this easy, 2 years past the date you turned it in. That's that's the easiest way to say that. And that it? Yeah.
Now it's my turn. Here's one major difference between legislative lobbying and executive branch lobbying. You can make campaign contributions to elected officials on the executive branch side. The legislative side, you can't if you're a legislatively registered lobbyist. But if you register with the Executive Branch Ethics Commission, you can make contributions. As a matter of fact, not only can you make contributions, but the contributions to that elected official are not considered gifts. They're specifically exempted out of our gifts rule. So you can give them, and the elected official can receive them. I don't know why there's this major difference. Both codes were written at the same time. Now, there are some penalties. If you don't do things correctly, there are some penalties. And as I mentioned before I go through any of these penalties, if at any time you realize you've inadvertently left something off, or maybe intentionally left something off and you've had a crisis of conscience, you can always amend your form. We always accept amendments. In my time with the commission in the last 8 years, we've only charged less than 5 lobbyists, I think maybe 2. One major one that resulted in Senate Bill 6. So it doesn't happen very often, but there are penalties, keeping in mind that the Ethics Commission is a passive organization. We can't investigate a lobbyist unless we receive information that a lobbyist has violated one of these rules. Then the commission can open an investigation, but we can't just go looking for trouble. Trouble has to find us first. So keep that in mind. Now, some of the penalties that go along with this process: failing to timely file reports or remedy deficiencies could result in $1,000, $100 per day fine up to $1,000. Then there's a failure to maintain records. If you intentionally fail to register with the commission, or you knowingly fail to keep some receipt you're supposed to keep, or maintain the records you're supposed to keep, or knowingly fail to file an updated statement with the commission, that could result in a $5,000 fine on the civil side. And then there's also a potential Class D felony. The Ethics Commission is not a law enforcement agency. We don't prosecute the criminal provisions. We always refer that to law enforcement. So we will work closely with the Attorney General's office, the U.S. Attorney, the FBI, the KSP, all those entities. If you fail to pay the $500 fee per year, or file an initial registration or updated registration statement, or you provide false information, or you admit required information, that could result in a $5,000 fine or a Class D felony. Intentionally filing a false statement could result also in civil action from the elected official that's implicated in the forms you file. If you falsely state something related to an elected official or a cabinet official, so they have a private right of action against you. And then contracts. Any contracts can be voided by the finance cabinet that arise or result out of lobbying activity that violates any of these provisions. Contingency arrangements, I think I mentioned before, they're strictly prohibited. They have always been strictly prohibited as long as the Ethics Code has existed, at least since 2000. The Senate Bill 6 did not create a new provision for contingency fees. It's always been in there. When the lobbyist who recently violated some recent laws and now is in federal prison, he was violating a law that already existed. Now, the Senate Bill 6 expanded this, further defined what it means, but his conduct already violated because he did not register with the Ethics Commission for 15 years and engaged in lobbying activity on behalf of his client for 15 years without ever registering. Then he received payment that was a percentage of the contract the state agency had with his client. Every year, his payment changed based on the percentage of a business that that client had with the state agency. That's a contingency fee arrangement. So you can't receive compensation that isn't contingent in any way on the outcome of the executive agency decision you're trying to influence. This includes payment based on the awarding of a contract or payment of a percentage of a government contract awarded. This is a Class D felony. Furthermore, an employer who enters into a contingency fee arrangement with a lobbyist, you could be barred from doing business with the Commonwealth for 5 years if you engage in such contingency rate arrangements. And the 5 years is measured from the date that the Executive Branch Ethics Commission learns of the arrangement. So again, in this example I had, he engaged in this conduct for 15 years, and the client paid him for 15 years on this contingency fee. The commission didn't find out about that conduct until 2 years ago. So we can go back and look at that. So that is this training. We will be available here for any of your questions until 4:30 if we need to be. We have this executive agency lobbying handbook. If you believe this applies to you, come up and get one. If we run out of supplies today, we will have the PDF on our website. We will also provide a recording of today's training on our website. So if you have other employees of your firm or other individuals you know who would be interested, we will eventually, hopefully within the next few weeks, put this on our website. The training we did on June 21st that really goes into the statutes and into the weeds much more, we will be placing that on our website as well. So we really appreciate your interest in coming here today. And does anybody have any questions? Please come forward and talk into the microphone at the front table so that everyone can hear your question.
Couple of quick questions, if you don't mind. With relation to compensation and the reporting on that, under the Legislative Branch Ethics Commission, which I think a lot of us are more familiar with necessarily, it's done on allocated to time spent on actual lobby. Is that acceptable for reporting here because of the nebulous definition?
So we don't have a definition. So frankly, if whatever you put down, we're going to accept that as accurate. When you initially file, you may not have been paid anything to date. So you're only having, the way the statute is written, Senate Bill 6 is written, it's past tense. So you would only indicate anything you've received from the date you sign that initial registration. Then when you go do your update the following filing period, you would list any type of compensation you received during that filing period.
Yeah, my question relates to the updated form at the end. So my question once again is, can we use the allocated percentage of time used on executive branch lobby, or does it have to be the gross income?
I don't know if I understand your question.
All right. Let's say that I'm paid $50,000 in a calendar year, but only 10% of my time is used in executive branch lobby.
You would only indicate the time you spend, the part of your salary that you're paid for engaging in lobbying activity.
Okay. Thank you. I wanted to make that clear because a lot of people are confused about that part.
We are too.
Okay. Well, as long as we all come to an understanding, everything's good.
Well, and frankly, if you listed your salary, we'd accept that. If you list your allocation, we'd accept that because, again, the statute's not clear, and we hope to get clarity at the next session.
Okay. The definition of substantial issue, I saw that as we were going through. What is the definition of a substantial issue?
Let me find that slide.
Because I didn't quite understand.
And anybody who's leaving, if you want a handbook, come up and get one. Get back to it, because I want to have this up on the screen as I'm going over it.
Certainly.
Did I already pass it? So a substantial issue is going to be if the decision involves either the expenditure of state funds over $5,000 or would financially impact your client or employer. That's the definition of substantial issue.
Okay, so for example, if I was working on behalf of a construction company related to silt fencing on a construction site, as to the placement of it or anything like that.
Is this related to a contract that's already in existence?
Not a state contract.
Okay.
According to what I'm understanding here, if there's a regulation in place related to something that would impact one of my clients, whether it be...
So you want to make contacts to an executive agency official to influence them to change the regulation?
Correct.
And that regulation would result in some kind of benefit to your clients
There would be a
financially?
financial impact in terms of installing the silt fences or what that would be.
Then I think you would need to register.
Okay, then that would be a substantial issue.
Yes.
Then. Okay, and then another question, and then I'll leave the dais. The complaints that you referenced in terms of what would initiate an investigation by the Ethics Commission, are those anonymous or are those open?
No, we have a specific statute that says anything that comes to us that results in an investigation is kept confidential.
Oh, so they are anonymous.
They can be anonymous, or we can know who they are, but we have to keep their identity confidential.
I see. Okay, thank you.
You're welcome. Any other questions?
I wanted to ask about who was paid and who was not paid. I'm assuming if you have a professional association and you have interaction with a professional board, that would constitute executive agency lobbyists.
Well, who is the you? Is it just a member of the association who's
I'm
not
saying the
paid?
association itself. If for instance the KMA or the architects wanted to contact the Board of Architecture or the Board of Medical Licensure about an issue, that would be an instance of executive agency lobbying. The way I read this, is that correct?
Right, but my question is, the officials of the association making the contacts to the state officials, are they being paid by the association to make those contacts?
That's my question. If you hire somebody like me to represent you, in interacting with one of those professional boards,
Then yes, they would have to register.
So the question though is an executive director, does that?
If the executive director is paid and part of his job is to lobby on behalf of the association, then yes, he would have to register.
Okay.
But if
and how would that be determined? I guess would it have to be in their job description, or just in practice that they interact on a regular basis, or I mean, how do you arrive at? I guess I could see a big gray area there where at some point it's maybe not your main job function, but you occasionally do interact with those people. So.
Right. If the executive director, if it's understood between the association and the executive director that part of his job is making these contacts to lobby executive agency officials, then that would still be the substantial basis.
Okay.
If it's to make the contacts for $5,000 or for financially impacting the client.
But if I'm like a licensed architect or engineer, and I as an individual I interact with my licensure board, that would be outside the scope.
Right. So individual members of your association, they're paying to be a member of the association. They're not being paid as an employee of the association. Okay. So if they're making contacts, they're just exercising their First Amendment right to free speech, and they're not being paid. They're volunteer to represent the association. They don't have to register. Okay. But the executive director, who is paid by the association, if it is one of his jobs to make those contacts, then yes, he would have to register.
Okay.
Do you agree? Okay. Any other questions?
Bear with me. I understand that we went through quite a few examples where if lobbying is not part of your main role, or I think we have a term here, main purpose, that you don't have to register. However, if with LG&E and KU, we're a heavily regulated utility. We deal with the permitting process and quite a few actions in front of the Public Service Commission in different areas. We have people spread throughout the company who have these communications on a regular basis. And you give the example of a highway official or contacting a highway official to move right-of-way lines. If that's somebody's job, if they're not paid to lobby on our behalf, but they work constantly with seeking and getting permits for us, so they are making contact regularly with these officials in the permitting process.
That's part of the regular process, like I mentioned.
That's
Yeah.
where I looked. It's part of a regular outlined process.
Yes.
Is that somebody who needs to register?
No.
Okay. And so then I have that question in kind of in another way or in another setting, dealing with, let's say, like OSHA, on OSHA regulations, or if there is an investigation of some form. So you're essentially answering questions and performing, our company employee would be performing their duties regularly like they would do with OSHA, but they would be trying to determine the outcome of...
They're responding to the investigation of OSHA.
Right. They're participating in an outlined procedure is the way I look at it. That's a procedure that's outlined in the regulation, but they are trying to influence the outcome of an executive agency decision.
Right, but during an open, the process that's already established by law. This is talking about if you're making contacts outside of that to try to influence the changing of that process.
That's great. No, we just wanted to clarify and make sure because we didn't want to end up with all of a sudden 30 people registered.
Sure, we really don't either.
Thank you. No, nobody wants that.
Thank you. Any other questions? Okay.
I know that there is, having sat through this training, there's some gray area on agency, departments, and boards or commissions. What is an executive agency? But, and I don't know if you can give me a definitive answer right now, but like I'm thinking of like quasi-governmental, independent corporations that have been created through statute, but their board has been, their board falls under the governor's like boards and commissions. And so whether that activity outside of normal public commenting, advising on their committees, that sort of thing, if that constitutes, I'm speaking specifically of like the Kentucky Housing Corporation and the work that
So if the governor has control through either appointing a majority of the members of the board, or some other statutory control, then it would be just like any other state agency, even though it's a quasi-governmental corporation. I think in my research, and I could be completely wrong, there are only maybe 3 or 4 boards out there, board commissions out there that are created by statute that the governor doesn't appoint the majority of its members. So if the governor appoints the majority of its members, then yes, they
would be a covered agency.
They would be a covered agency.
And yeah, okay. Sorry, I may have to register.
The Kentucky Housing Corporation is actually listed under the agencies that when I held up the form that you check off that you anticipate, that one, and Kentucky Higher Ed Student Loan, that's another one that's listed.
Oh, I don't have anything with them.
Yeah, and that original listing of executive branch agencies was taken when this law was formulated. LRC used to produce a bulletin that had everything that fell under the executive branch, and that was the boilerplate we used to create our list. And that's traditionally always been Kentucky Retirement. I mean, it's run by a group of outside entity, board people that are appointed by the governor, but it's also listed, and it's under the finance cabinet listing.
Okay.
There.
Thank you for the clarification.
Yeah.
You're welcome. Any other questions? Oh. Be here till 4:30.
Sorry.
I gotta pick on that.
So let's say that as executive director of an association, you are not directly talking to agency officials, elected officials, but you send out a communication to your members encouraging them to contact. Is that?
You have to make direct contacts.
Perfect.
You agree? Yeah, but he's not making the direct contacts. Yeah.
I've got several questions. I work primarily in the environmental and OSHA areas, and where we have permits that the state agency is putting together, and we go in on behalf of our client to work with the agency on what's contained in that permit. Is that executive agency lobbying?
So you're just applying for a permit through an existing government program?
No, we're not applying. We've applied, and what happens typically is you sit down with the agency to work out the details of what's in that permit and the terms and conditions of that permit.
No, that wouldn't require registration. Do you agree?
So you're saying it's fluid depending on...
It can be fluid.
But it's just they're applying for a permit through an existing
I
government
can see that
program.
the application, no. But I'm saying we sit down typically, I mean, I think everybody in this room maybe that does this, will sit down with the agency on a permit to review the terms and conditions and try to get some of those modified, improved, or whatever.
But again, this is you trying to make these contacts outside of an established process. Like if you were trying to get the agency to push legislation to change the permit process.
No, I'm talking about an individual project that is within a process to try to get the terms and conditions of that permit or approval modified in some manner.
Right, but the permit itself, the process is already established.
Technically, yes, but the details,
But whether or not you receive the permit requires you to go through this process.
well, what you're required to do in the permit specifically is not in the typical process. I mean, I can sit back and do nothing and a permit gets issued or an approval gets issued, but it may adversely impact my client, where I can go into and meet with the agency and say, can this be done? And
So if you look up at the screen, it's got a list of the executive agency decisions that you have, in order for you to register, that you would have to be trying to influence. So the first one is you're trying to get some sort of contract, grant, lease, or some kind of financial arrangement. That doesn't fit your example.
Nope.
The next is you're trying to influence the parameters of a state contract.
nope,
Okay, not that one. You are trying to influence, request future existing budget provisions.
Nope.
Doesn't fit that one. The issuance of administrative regulations or rules.
nope,
Nope. The issuance of an executive order.
nope,
The issuance of legislation.
no.
Or any other public policy decision of a state agency. And I don't believe, again, we don't have a definition of what that means, but if you look at all the others in the list, your permit process is already established by law somehow, and you're just trying to influence the issuance of that permit.
Yes.
Okay, then I don't believe you have to register. Do you?
No.
Okay, no, I don't, you wouldn't have to register in that context.
Scott, quit now.
I mean, if you can always exercise out of an abundance of caution and register with the
I'm
ethics
just curious
commission.
what the permit, I just find that highly unusual that you're going in to get, a permit, that there's conditions, and you're changing the conditions each time you go in? Okay.
Yeah.
I've
again,
been told to quit.
Yeah. So, if to anybody in this room, if you want to register with the commission, even if you don't fit any of this, we'll take your money.
Okay, I'm asked to serve as a representative of, let's say, the Kentucky Chamber on work groups that,
Are you being paid?
Sometimes yes, and most of the time no.
For the times you're not being paid, don't worry.
Okay.
But if you're being paid, then we go to the next question. Then finish your sentence.
Okay. The agency is developing regulations. They get a wide variety of people to represent different points of view as they put this together.
Okay,
these
so
regulations together.
the executive branch agency has decided on its own to fix its regulations, and they've asked you to participate in, say, a committee to review their draft.
Yes.
Then no, you would not have to register. You would have to register if you go to the agency and try to influence them to change their regs. But if it's the other way around, the agency has decided to do it, they're just asking for
Input.
then no, you don't have to register.
Okay. Thank you.
You're welcome. Anyone else? Wonderful. Well, again, in the PowerPoint, please take a copy of it. The last page has our contact information. You've got the direct dial number for both Jenny and myself. Please come up and get a handbook if you think this applies to you, or even if you're just curious about learning more. And we really appreciate your time and coming today. And we appreciate your input. Thank you.